Okay, I'm gonna just get it popping, y'all, with a little read that I found. I thought I'd look up and kind of help y'all understand why I would use a power of attorney in a court case, the way I would use it. Okay, because I see people use it when I talk about a power of attorney being able to take control of your court case, and most people, and include myself, have not told y'all exactly how I would use one and why it's so important to have one. Okay. A power of attorney, again, I might want to start off with reading the definition of a power of attorney, and then I'm gonna get into the mechanics of how I would use one. Power of attorney. Okay, and I've already read this before in previous videos, but for the sake of this this video helping you, for clarity, I thought I'd go ahead and read the definition of a power of attorney. Okay, the power of attorney is an agreement between two parties, principal and attorney in fact. The attorney in fact need not be attorney at law, a lawyer. So it don't have to be an attorney, an actual attorney at law, a bar member. It's a power of attorney gives the attorney in fact rights to act in the principal's place. Attorneys in fact are fiduciaries of the principals. Okay. That's the principal is the all caps name. Okay. In general, as a matter of fact, it says according to the definition, I'm reading from Cornell Law. It says in general, a person or thing that is more important, that is more important than others when identified for a particular purpose. More specifically, in various contexts, someone who authorizes another to act in their place. This is and it says agent, fiduciary duty. That's the number one definition. Number two says the basic amount of debt invested, which excludes any interest, profits, or other additional earnings on the basis underlying amount. Number three, someone with primary responsibility to perform an obligation. That it says surety. So they see the principal as the surety. Okay. Keep in mind, the all caps name is a principal. So I'm having you understand the definition of a surety. Okay. Number four definition. The corpus of a trust, which is composed of the assets funding the trust. Okay. Keep in mind, everything you bought is in the name of your straw man. I'm using straw man for the sake of understanding so y'all can get it. Because people who starting off on the beginning stages of this stuff, you understand when I say the principal, you understand the straw man, the all caps name, it's the same thing. Okay. The principal, the all caps name, is the United States citizen. That is the entity that you're supposed to be controlling. So it says the corpus of a trust. Corpus means the body of a trust. Okay. Which is composed of the assets funding the trust. I don't want to confuse y'all using the word corpus because I don't want you to think. Anyway, let's just stick with it. Okay, let me stick with what I mean by it. Let me get off on because I was reading what the definition of a principal is. The name in all caps is the principal. Okay, there's 4 different definitions. I read all 4 of them to you. So now I want to go to the definition of jurisdiction, because a lot of you don't understand jurisdiction. The term jurisdiction, when you're talking about giving someone jurisdiction. Jurisdiction is merely the power and authority. I'm reading from the Black's Law Dictionary, 1933 version. I think it's edition 3. It says the power and authority constitutionally conferred upon or constitutionally recognized as existing in a court or judge to pronounce the sentence of the law or to award the remedies provided by the law upon the state of facts proved or admitted, referred to in the tribunal or decision, and authorized by law to be the subject of the investigation or action by that tribunal, and in favor or against the persons or arrears who presents themselves or who are brought before the court in some manner sanctioned by the law as proper and sufficient. They had to draw out the damn definition to be so damn long. But in short, it's saying the power and authority to constitutionally confer upon a court or judge to pronounce the sentence of the sentence of the law. So there's their power to be able to do anything for you. If you don't want to bring in the case, they got to have the power to even do anything about it. You have to give them jurisdiction in order for them to have the power to do anything about giving you your remedy. Okay, if they don't have jurisdiction to do that shit, then they can't do anything. It's like if you got a 9(8) trust. Most people know a 9(8) trust, a 9(8) entity. For the beginners, a 9(8) entity is an entity that has a 9(8) number that starts with an EIN number that starts with the series 9(8) at the beginning. Got 9(8) dash and then the other 7 numbers. That makes it foreign. That means the principal address of that entity is in another country outside of the United States of America. So it's totally foreign to this land. Okay, so no judge in this state, no judge in this country, the whole United States of America can adjudicate a case that you can't bring a case with that name right there unless somebody actually injures you here or whatever. But in most cases, they don't have the jurisdiction to come after that entity and adjudicate any kind of judgment against that name, because it's out of the judgment. They can't do nothing about it. It's like a Georgia police officer trying to go to Alabama and try to arrest somebody. They can't do it. They don't have authority to do anything to any work on that across the state lines. They have to stay within their area that they're actually they're commissioned to do work here. They're here in Georgia. They can't go to Alabama and arrest nobody. They have to call the authorities that have jurisdiction over in that land to do their job. So the same thing, they have to have authority to constitutionally confer upon a court or judge to pronounce the sentence of the law, or to award the remedies provided by law. You can't even give award of the debt, or they don't have jurisdiction to do anything. So if you have to grant them the authority to do what you need them to do, okay? Now, when you're talking about the power of attorney, you're revoking the power of attorney, any previous powers of attorney. When you're using the power of attorney in your court case, you want to give them instructions as to what you're authorizing them to do at that point. Once you revoke any previous powers of attorney, you revoke the previous one. Now, right now, this is what I'm authorizing you to do. That's what your objection should have written on it. Now let's go to Rule 12B. 12B, Rule 12B. Look in your Cornell Law if you want to look it up. Just type in Rule 12. Rule 12B as in boy, lowercase b, not capital B, lowercase b. It says, how to present defenses. Matter of fact, I think I want to show y'all this. Let me see if I can do it without tearing up my damn stand. Hold on. Right here. See right here? Rule 12, defenses and objections. So if I'm using the power of attorney after I have served according to the state here in Georgia, and most likely your state too, but look in your state to confirm what I'm saying, to see if it's required that you record the original power of attorney with the proof that you served any parties that you want to serve, like say the judge, the county clerk, the child support agency, whoever that attorney opposing party representing, the opposing party's estate. You serve them, copies of your power of attorney where you are actually stating that you are the attorney, in fact, over your own estate, and you're rebutting the presumption of the death and the presumption that you're incapacitated. So that's the type of power of attorney I created. Okay. Now, because you're making your natural name, upper lowercase name, the attorney in fact over the all caps name. Okay. Now, when you serve that, I would specifically name those people I want to serve that to in that power of attorney. And you have to state, according to the state statutes, you have to state in that new power of attorney that all previous powers of attorney are hereby revoked. You have to make that statement in there. I've seen that in every single state statute. Now, some states don't require you to record that original power of attorney that you just created and the evidence that you served everyone, that being the maybe a Xerox copy of the green cards you may create that you may get back from in the mail. They may look like this here when they sign off on it, the green card. Or, you can go on the United States Postal Service website and type in the tracking number. That will be right here at the bottom. Type that in the little white label right there. Type that number in the U.S. Postal Service, the tracking number, and then it'll show that it's been delivered. You could print that page out, attach it to your original power of attorney, and record that in the county recorder's office. That's if your state statutes, if your state requires you to record it. You have to read your state statute to find out whether or not it's required in your state statutes. You know what I'm saying? Now, when you do that, now you have created a record, a public record that proves that you have served them a power of attorney, a new power of attorney that revokes any authority that they have been operating under previously, that gave them the power to administer your estate, without you even knowing it. Okay, because according to my previous videos, everything I looked in other states, they can actually administer your estate without you even knowing it, without even your consent. Once that original power of attorney has been put in place, now they can delegate powers without even coming to you about it first. So you want to revoke that. Okay, now if you got a case coming up, or you got a case that's already put in place, this is how I would administer it. This is how I would do my case, okay? I wouldn't use other people's shit to go along with that. The power of attorney is all I would use, okay? It's all I would use to shut it down, because the power of attorney gives someone, as a matter of fact, did I read the definition of a power of attorney already? I think I did already. Let me see. As a matter of fact, I know I did. Power of attorney, yep, I read it already. So it's basically where generally people use it for, like, say, if I want to give like my father gave me power of attorney over his estate. But the thing is, because he can't do things on his own, I have to do things on it. I have to do things for him on his behalf. So keep in mind that the Cesta KV Act of 1666 presumes, in every state does this. Every entity does this. Even your bills, your bank, Social Security Administration, they all do it. The presumption of death after 7 years is generally the number. 7 years, you're presumed dead after that. Okay? And you have to rebut that presumption of death. Whether you presume dead or incapacitated. Some states use the word incapacitated. Some states use the word absentee. But bottom line, you have to prove that you are alive. You're still here. So when you take control, and when you do that, the power of attorney actually does that. So when you serve that to the judge, the county clerk, any entity trying to administer your estate without your consent, and that power of attorney specifically says that all previous powers of attorney are hereby revoked, you have officially done exactly what the state requires you to do with revoking their power to administer your name, your person, your estate. Your name, the name of your name in all capitalized, in all caps, is your estate. Okay, that's the name of your estate. Now, let's go to Rule 12B. Okay, Rule 12. At that point, this is why one of the reasons why I don't understand why people don't want to use motions right here. I don't understand why they won't use a motion. That's their system. You can't change their system. It's their system, because you want to do something different, and then you say they do what they want to do when you won't do what the fuck you supposed to do, because you want to make up a damn system. You're going to make up some shit the way you want to do it and wonder why you're not getting no movement. 12B. This is 12, Rule 12, lowercase b right here. How to prevent defenses. Every defense to a claim for relief. You want to get relief. If you want to get all child support, that is relief. In a pleading must be asserted. That's whether you own child support or you own it, or you're trying to stay off of it. You're trying to get relief. You're trying to get rid of it. It's a defense. Okay. Okay. In any pleading must be asserted. Keep in mind it says he who fails to the maximum of law says he who fails to assert his rights have none. It must be asserted in the responsive pleading of if one is required, and it says, but a party may assert the following. There's that word assert again. Must assert the following defenses by motion. This is why I wonder why y'all always shoot shit on motions, because y'all done heard some fake ass guru tell you we don't use no damn motions. We use affidavits. Okay, why you can't attach it to emotion? It tells you this exact. They're telling you how to play the game right here. It tells you how to present a defense. So it says you must use defense by motion. Now, if you motion for when you're using the power of attorney, and you're serving someone a power of attorney, and you specifically stating that they no longer you're revoking their power to administer your person. Do they now lack personal jurisdiction? That is your person, right? Your name in all caps is a person. It's an artificial person. Okay? Your name in the upper lowercase is a natural person. What's on the docket is their name. The name in all caps. That's personal jurisdiction. They don't have jurisdiction. Remember what we just read about what a jurisdiction is. They're basically the authority. Where is that? Let me see if I minimize that real quick. The power and authority to constitute to do this here. They have to have the power and authority. They don't have any power and authority to do any damn thing if you revoked it from them. Okay? Now, so at that point, once you have revoked their power to even continue to railroad you the way they railroad you, now in your defense, you also want to give them instructions. You know what I'm saying? You want to give them instructions, and it's their fiduciary duty as trustee to operate as you need them to operate, to give you the relief that you need. This is how I would use the power of attorney. So how somebody else would want to use it, that's totally on you. You do it however you want to do it. And whoever that is that keep on commenting at the bottom of my videos, that's on you how you want to do things, okay? I forgot the guy's name, but you do things how you want to do things. But don't come on my stuff comment talking about this is incorrect and that's incorrect. You do what you want to do and teach that on your channel. Don't come on here trying to tell me what I'm doing when I know what I'm reading in the law books. Okay? If you have your own perception on how you choose to do things, that's totally up to you. Okay? But respect my side over here. I don't go over there trying to see if I can pick and shit and find shit on shit that you said. Now, don't do that. Let's show some respect on these channels, okay? So I thought I'd throw that side note out there. But this is how I would use the power of attorney. So when you take power from them to administer your person, your name, your estate, your property, you literally just took power. You just took personal jurisdiction from them. And now you want relief. You have to use that, mention what relief you want in your motion. And don't go all overboard talking about you want to try to charge, you want a child in your motion. You want to talk about I'm countersuing for $2.3 million. That shit is not even reasonable. Just get off child support, man. Get them to leave you the hell alone. And if you want to go back and sue later, that's on you, but you're trying to get off. A lot of y'all try to do too damn much by doing all in your paperwork, trying to be unreasonable based on some shit somebody on the internet done told you. Now you think you can use a fee schedule they got ridiculous amounts like $1 billion an hour and all this old dumb shit. You're not gonna get no damn $1 billion from these folk. Are they dealing with you? You know, we got to be reasonable. Use a little wisdom when you're trying to get your peace restored, trying to get your rights enforced. Just use a little wisdom with this here. So that's how I'm gonna do. Like even with my child support case, I use the power of attorney too, just to kind of shut all this stuff down, and then I filed a defense into the court case. I didn't know what is that? I got it over here somewhere, but that's not the purpose of this video right now. But I thought I'd make a video to show y'all exactly how I would use my power of attorney in a court case, and that's how I'm going to use mine. I ain't trying to shut it down because I'm counterclaiming in my court case because I want my boy back. So I'm using mine as the counterclaim, but those are the instructions I'm giving once I've taken previous power of attorney. I'm giving instructions in the answer as to what I want done, and I'm invoking equity in my answer because, for example, my son needs his father and his mother in his life, not just one of them, and you're not going to turn him into a debt slave while you try to use my child as a slave, as a subject matter to enslave the father when that's not equitable on no side. My son don't even benefit from that. So that's why I'm using that equitable angle, you know, to get what's to enforce everybody's right, so my son gets what he really needs. That's the best interest of the child. So anyway, I thought I'd go ahead and make this video to kind of help y'all understand how I would use a child support, how I would use a power attorney to either read child support or stay on child support. So that's for you who actually doubt the power of attorney. It seems so damn simple, but it seems like so many people want to shit on it or just sleep on it. You know, not many people shitting on it, but you got people that sleep on it. They'll call me all damn day about a power of attorney, but they have not done one. Like, why have you not done one? That's like the easiest thing to do. You go on the internet, you can find a template and tweak it. It's just too easy to create one. And you might, when you get done doing that, you might want to go ahead and get ready for some new shit, because I'm gonna be endorsing. I done started endorsing bills now, so I'm gonna start probably giving some classes on that once I start getting some success. I don't want to put all of everything I learn on need to be on the internet, because some people they squander information, and I don't want to cast my pearls, but upon swine, as they call it, upon swine. So I want to make sure, Anyway, I'm gonna get on off of here. I don't want to get off into that, but we'll talk on the next video. Hopefully, all y'all like and subscribe already, and I'll see y'all in the next video. Emerald signing out.